sorry about the slightly late start. Justice Stuart-Smith, yes, so embarrassed by its performance yesterday, it went into hiding. We've got it. Yes.
I think Mr. Platt. Yeah, well, just before we start, I've handed up a schedule of minimum permitted concentrations as proposed in the request from Lord Justice Stuart-Smith. I hope it's comprehensive.
Thank you very much indeed, yes.
Lords, I'll try and do this within 3/4 of an hour or so. My learned friend Mr. Rawlinson points out that I should have drawn the court's attention to one part of the document I was referring to yesterday. It's supplementary bundle 2 in the Cuthbert appeal, page 185, which was part of that asbestos promotional leaflet.
Yes.
We're not sure what the date is, but 50s or 60s. And as he rightly points out at the bottom right of 185.
So sorry.
It may be enough if I just read it out. It's only one sentence.
Which page are you on?
185.
Thank you.
Lord. Just before the page, I took the court to where there were some photographs of the man sawing and drilling without parent protection. 185. Dust extraction, bottom right. For quantity machine cutting in an enclosed space, a dust extractor is essential. How that is read by the person to whom this is addressed is debatable, but that we would suggest or advise not simply indoors, but in an enclosed space in which machine cutting is in quantity is carried out. We've made the point that throughout the 1950s, the period with which we are concerned, there is no guidance in the Chief Inspector's reports or other documents emanating from the state about dangers in relation to construction work. My Lord Vice President yesterday asked me about the position in relation to the development of asbestos products after the war, and there's no doubt that there was a huge increase in them and that they were used very much in construction. But we say at the time, and that is the time we're concerned with, it was not apparently realised by anyone that there might be a danger from, as it were, the incidental use of asbestos products in construction or construction and building sites. The one exception, which was referred to in, I think, the 1956 Chief Inspector's report, which goes beyond the scope of the 1931 regulation, was the removal of old asbestos lagging of pipes, which might be something which is encountered in a construction project or might not. But that's the only express reference to an activity for which concern was expressed by the Chief Inspector. And that's important because when we come to look at Jeremson in a moment, very briefly, one of the key points there was that there was an explicit warning instruction given to ship owners and shipbuilders about the dangers to be encountered in that context. The document that I didn't quite get to yesterday, but which is in fact in the white.
I just noticed, I don't suppose it's important, otherwise I'll tell you we've been on to 187.
Yes.
Into the supplementary bundle 2. Sorry,
yes.
My Lord's broken it away. Contractors are advised if they want to use a filler, they can collect asbestos dust and mix it with paint to make a filler.
Yes.
What occurs to me though is that doesn't suggest that the sort of incidental contact with dust, which that would presumably require, is regarded as dangerous.
Well, it was certainly dangerous advice because, of course, this is from manufacturers of asbestos products, and they ought to know that those sort of risks of mixing in the factories covered by the 1931 regulations are the subject. But that's a good example of how the literature was not alerting anyone to particular dangers. Now, this is from the manufacturer, but I made
Well,
the
anyway,
point.
that did seem to me to be a possible point that could be
Well,
made.
I hadn't noticed that, but that is certainly a point that we would say could be made from that. But Lords, going a document which is in the white reference literature bundle, which is at page 644 in the hard copy, so it's probably in volume, second volume of the hard copy we have, but I don't quite know what the version is. And it's page.
It is indeed the second bundle.
And for those looking at it electronically, it's page 346. Electronically.
644, did you say, or 664?
644.
That's tab 24.
Thank you. And this is the Department of Employment and Productivity, I think it stands for DEP, and it's a Health and Safety at Work number 44 booklet, Asbestos Health Precautions in Industry 1969. So that's of some significance to date. And the only matter, it's a practical guide to precautions that should be taken, but I only want to draw attention to what is said on page 6550, which is electronic bundle 352, under the heading Health Hazards. Asbestos, however, is a dusty substance, and it is unfortunate that the dust of this very useful mineral can be highly injurious to those who inhale it in sufficient quantities. And they summarise the history of this developing concern. And then in the middle of that paragraph, still more recently, a relationship has been demonstrated between exposure to certain types of asbestos and the occurrence of mesothelioma and cancer of the pleura, and so on. Then the next sentence is important. Whereas asbestosis and the lung cancer associated with it have only arisen in workers who have been exposed for years to heavy concentrations of the dust in asbestos factories or in processes in which asbestos is used, mesothelioma has developed in some individuals with short periods of exposure. Now that is a succinct expression of the government understanding, factory inspectorate presumably, as late as 1969, and for all we know, that could well be the understanding today in relation to asbestosis, of the risk of contracting that disease. And we say, obviously it's long after our period, but how could it, we ask rhetorically, be said that that 15 years earlier, up to 15 years earlier, there would have been any basis for a contractor, even a large one like Taylor Woodrow, taking any different view. Can I now turn to briefly to the facts of this case and what Mr. Cuthbert said? There's a I'm sorry.
Just reading on the next heading. Follows on and basically identifies various sorts of situations in which asbestos risk may arise, or exposure to asbestos dust may arise.
It would cover our case because it goes on to say those in which the products are handled in such a manner that dust is evolved. So that no doubt, like you said, to cover construction work. Although we say there's a world of difference between this sort of case, where the asbestos products were being used incidentally in a large building project or a medium-sized building project for soffits and some interior.
Well, what I was just noticing was, if you look at heading 2, contractors carrying out work involving use of asbestos may be found in dockyards, shipbuilding, ship repair and generating. And the last one, large building products, industrial and domestic, on insulation and repair of heating apparatus.
Well, that's
e.g. in schools.
Lord, demonstrates I hadn't read this sufficiently, because that is yet another example. And again, we're using this purely as a way of inferring what advice, if it had ever been sought in the 1950s, would have been. And it is, again, it's the lagging that they're concerned about, which is why it would be large building projects. And things get so obscure because once you get to the risk of a malignant disease from low dose exposure, it really doesn't matter. You don't need to worry from then on what the risks are in relation to asbestosis, because if you take the precautions to avoid low dose, you cover both risks. And if it were the fact,
hang on 1 second. I don't know where this goes, but at 656, they do address the question of as when they're now getting much closer to our facts.
yes,
Although it hasn't appeared in 650. Bottom of the page, a considerable number of asbestos products such as asbestos cement sheet, asbestos wallboard. So that really is asbestolux included
Yes,
in that, are used in the building and shipbuilding trades. So forget shipbuilding for them, just building. Fitting them into the position, these products had to be cut and dried.
well, there's no doubt that at that stage they are getting concerned about all sorts of activities involving asbestos products.
All right, but you were just taking us through you were taking us this particular document reflecting the position in 1969, and I take all the points that's much later and so on.
Yeah.
But I think if we were going to draw anything from this document, one would need, in your favour, one would need to look at it as a whole.
Well, Lord,
and the passage I've drawn your attention to perhaps slightly mitigates the point you're otherwise making, that nobody seems to have thought there was a risk in this sort of building.
Because of the mesothelioma risk. That is, by then,
all right.
The risk has arisen. And so what I submit I'm entitled to get from this is a statement of the understanding in the centre, in the department, of the risks of contracting asbestosis. In other words, what they are saying is, if this mesothelioma risk hadn't appeared, then they wouldn't have been.
I see that.
Talking about construction.
I see that. I just wanted to make sure we had the whole picture. Okay, thank you.
And this isn't inconsistent with what you're saying, but there's obviously further detail on the next page, 657.
Yeah.
Thank you. Yes. Well, it's all.
Right, thank you.
Yes. Well, although it goes, we say, in our favour insofar as it tells us what they were thinking about asbestosis, and insofar as they're talking about other the construction industry generally post watershed. The facts of Mr. Cuthbert's activities, we're content in this part of the submissions to take what he says literally. In other words, leaving aside my learned friend's ground 5 challenge and assuming that that's a good challenge.
Remind me which ground 5 is.
Well, the judge drew certain inferences which he says were effectively setting aside some of Mr. Cuthbert's statements. It's a factual challenge. It's to do with.
No, sorry, but what? Okay, carry on with the point you made.
So I'm content to address the matter at this point simply on the basis of what Mr. Cuthbert was saying in his in 2 witness statements, and they are in the the first supplementary bundle at page 265, the first one. And incidentally, he starts off understandably saying what report physical condition he was in. That's his first paragraph, which may be relevant to this suggestion.
I'm very sorry, I'm seem to be operating at about half speed this morning. Where are you?
265 of Supplementary Bundle 1. So this is the evidence before the court, and I made a passing remark about what he says in paragraph 1, and then in paragraph 7 he sets out the history of what he recalls in relation to Taylor Woodrow and his period. He was not doing a proper apprenticeship, but I was learning the trade of building. In fact, my job was really trainee supervisor. This is the job I came into contact with asbestos on a daily basis. He refers to the Queenswood School in Cheshunt. Further down, I was helping with the construction of the buildings, and I was looking after all of the trades. Just pausing there, so he's not confining himself to carpenters cutting up asbestos. I can recall carpenters cutting up asbestos sheets, and he describes them. Then he says what they look like. The carpenters were using them for soffits, which they were putting in just below the roofs. I talked to them every day as they were cutting up the asbestos and effectively supervised them. I saw them every day, it was a regular occurrence. To see them, I was often just a few feet away, and they cut up inside or outside, depending on the weather. They always cut up on the ground floor. I cannot recall whether they used power saws, but they did use electric drills. I'm sure that they were using hand saws for some of the time, and they may well have used electric saws too, as I think it was a combination. None of us were wearing masks and so on. And dropping down, the cutting of the asbestos was dusty work. And I, of course, got covered in dust as I was walking about the site, and as I was chatting to them. It was my job to sweep up as well, which I did throughout the day several times, as and when needed. I simply used a broom to sweep up any asbestos and other debris. Do not think we had a skip in those days. I think I simply bagged it up or put it in a large bin. So that was the extent of what he was saying then. His reference to dusty work is in fact confined to the cutting of the asbestos. He doesn't say anything about whether his sweeping up resulted in a cloud of dust or how that affected him. He's saying that he was standing a few feet away for some time, parts of the day. He doesn't say for how long. He then provides more information in his second witness statement, which is at
275.
thank you. And he says more about in paragraph 2, my job title was trainee supervisor. I was not doing a formal apprenticeship, but I was learning. I was supervising all sorts of different trades, including carpenters, bricklayers, and plasterers. From time to time, I supervised the plumbers. I was not in charge of a particular group of people. I was simply moving around the site. In the next paragraph, he says that they were cutting asbestos sheets. They were used on the outside of the buildings for soffits, but also in other areas. Some were used below on the ground floor for lining canopies or lean-tos. I recollect that asbestos was cut inside and outside the building every day. A lot of soffits that needed to be cut, and also a lot of flat areas that needed to be lined. It was a huge building with many canopies and lean-tos. Sometimes the 8x4 sheets did not need to be cut and were fixed as is. There were about 4 carpenters on site, and 1 or 2 carpenters were cutting the asbestos daily. I visited them every day and spent about 1 to 2 hours each day directly supervising them. I would be in their vicinity talking to them, answering any questions they may have. I also cleaned up after them. The area was a mess when I visited them. It would need cleaning up, and I simply used a broom and swept up any asbestos dust and debris and put it in a bin. I also handled any asbestos offcuts and put that in the bin as well. I simply answered any questions that they had. I did not usually cut the asbestos myself unless they asked me a specific question and I had to show them how to do it. Paragraph 4, when the asbestos was cut, there were clouds of dust. Did not wear overalls, simply wore, and so on. 5, the carpenters used to cut the asbestos in the basement, and then they took it up to the scaffold or wherever they had to go. 6, I did also supervise the plumbers, and I walked past them doing their work. I remember seeing copper pipes, and the pipes would have been lagged with asbestos. So leave.
Can I just
Sorry.
just raises that phraseology raises a question. So, in my experience, a soffit is normally the underside or conceivably the facing side, a facing side of an external roof
Yes,
where it joins the building.
There's a picture on page 206 of the same bundle.
206.
206, my lord. Mr. Phillips tells us what a soffit looks like.
But the actual fixing of soffits, in my understanding, is either always or virtually always exterior.
Yes. It's the underneath. It's
Okay, thank you.
and so taking that, leaving aside the criticisms of anomalies and inconsistencies and so on, we have a picture of someone who is doing some supervision, learning on the job as well. He seems to be learning to become a supervisor. He's supervising all sorts of trades, and he's standing a few feet away from people carrying out some dusty work with the asbestos. And that's a basis on which the experts could work out in very, very broad terms sort of exposure risks. He then gives a 1 to 2 hour estimate for his daily encounter with the carpenters. He doesn't quantify his sweeping. He does. He says it in the first one. I think he said a few times a day, although he's not saying he's just supervising the carpenters carrying out that work. So that was the extent of it. And what we say is that the result is that the occupational health experts had to engage with this rather artificial process of trying to work out what sort of exposures these might have involved. And the judge at paragraph 43 said eventually there was an agreement, effectively, that it would amount to 2 fibres per milliliter on a time-weighted average. That, in fact, was a generous finding in favour of the claimant in this case, because on the figures that the court was presented with, much lower levels of average exposures for particular activities would have been arrived at. The occupational health experts in their joint statement, which is at supplementary bundle 1 at page 1. Noted
Page
261, paragraph 12. They didn't repeat their estimates in their reports, but what they said was, in the middle of that paragraph, whilst we note that our estimates of the likely concentrations of asbestos dust resulting from the tasks described differ, we agree that the extent of any exposure is likely to be lower if the court was to find that the material being worked was asbestos cement and so on. Well, the court does find it's AIB. And then the last sentence is important. We also agree the claimant's exposure would have been lower than those engaged in cutting activities, perhaps by an order of magnitude. And that gave rise to some brief cross-examination of Miss Conroy by my own friend Miss Foster, which is at starting at page 27 of the same bundle. And just below letter D, she said, "I understand you both."
Yeah.
I understand you both agree if you're then attempting to calculate the deceased exposure as a bystander, you're going to divide the relevant figure by 1/10. Well, with respect to Miss Foster, I think she must have meant by 10, rather than by 1/10, because it's an order of magnitude. To account for his position as a bystander, you're going to further divide that resulting figure by 5 to account for the short duration of his exposure of 1 to 2 hours per day. You end up with a total division of 50 from the figure you started out with. Ms. Conroy says, I understand where the division of 10 comes from, because I mean his exposure is likely to vary depending on where he is in comparison to the process. Higher when he's near to it, lower when he's further away, very much a rough average. All we can say is that a factor of 10 probably equates to the whole lot. I'm not sure where the factor of 5 comes from. Well, because he's purporting to have been a bystander for 1 to 2 out of 2 hours out of any working day. Yes, I hadn't considered that in my report, but I agree that you would then, yeah. And then at 29, page, I think these are questions initially by Judge Freedman below letter F. This is, sorry, we must start on page 28 because there's a question just at D, which is asking Miss Conroy about her AIB debris for sweeping up to 100 fibres per milliliter in circumstances of poor control measures and work practices. And on the opposite page, letter E, Judge Freedman says, sorry, we'll go above that. The question from Miss Foster about D, he is of the opinion, that's Dr. Phillips, that the sawing would produce and generate 5 to 10 fibres per milliliter. And sawing of asbestos cement, well, we can ignore that. Do you accept these calculations? The only thing I would say is the generation between 5 to 10 fibres per milliliter, as I mentioned earlier, I think it's going to be the average with intermittent activity. Judge Freeman says, hang on a second, you say 5 to 10 is the average over a working day. And then it's rather inconclusive, but just below F, she says the concentration at source, so actually resulting from the task, which is likely to be higher at a given moment in time. Answer yes, during the inaudible activity, I'm sorry, during the cutting activity, yes. And then over the page, she agrees that this might be for a couple of seconds. So it's slightly confusing, but putting the two together, even taking, and I'll come to it in a minute, whether that's a proper starting point, 100 fibres per milliliter, you immediately, on the claimant's own account, you divide that by 50. Even if he was sweeping up for an hour a day.
You divide by 50 to get to the time-weighted average.
Yes, exactly.
Can we just go back to the judgment? Because certainly the way that I read it was that paragraph 43 says, is a finding that assuming he was indirectly exposed to dust for 1.5 hours per day as a result of the carpenter's cutting up AIBs, and assuming he spent 10 minutes sweeping up at first, then there was an agreement about 2 5 minutes. But his actual finding was at 36, which is a much lesser. He doesn't accept that it's 1.5 hours, and he doesn't accept it. So, but perhaps wisely, he doesn't then try to quantify the further reduction. He goes at 45 to say this evidence is consistent with my impressionistic approach. Have I understood
that's
the judgment correctly?
And as I say, I'm addressing the court on the basis that we take literally what was said in the Mr. Cuthbert's witness statements, ignoring the judge's conclusions that there's an implausibility in them. So we do have 1 to 2 hours.
So if you take Mr. Cuthbert's evidence at face value, then you're at 2 fibres per mil.
Well, you are only in relation to the sweeping up, starting at 100 and boiling it down. No, I'm sorry, that's wrong because that's the 10 minutes of sweeping, and he didn't quantify that.
No.
But if you take 1 to 2, if it's 2 to 5 to 10 as at the carpenter's face while he's doing it, then you divide that by 10, order of magnitude, to get for the bystander. So that becomes 0.5 to 1 fibre per milliliter. You then divide that by 4 or 8, depending on whether he's doing it for 2 hours a day or he's standing beside them for 2 hours a day or 1 hour a day. And so it then boils down to a range of 0.062 to 0.125 fibres per milliliter.
Right,
So,
can you just stop that? Is that calculation, because I'm not going to remember it, is that calculation in the papers?
no, I'm afraid it's not.
Someone
No,
puts
you'll
it on a
show
piece-
it's an argument.
Put it on a piece of paper.
Not in my skeleton argument. It was calculation I did last night. So I'm afraid it didn't fit. We can certainly provide it, and obviously I don't want to put to the court something.
Well, it's
which-
very short. Rather than you, why don't you just? I mean, we heard you do it.
Yeah. I can
take it, just do it now at dictation speed,
Yes,
and then
very
we'll
well.
have it, and that's
Well-
fair to Mr. Rawlinson than having to wait for a note.
The carpenters are exposed to 5 to 10 fibres per milliliter.
Okay,
As they're
carpenters
doing
are
the job.
exposed to 5 to 10.
And I'm afraid I've forgotten where that comes from. Where does the 5 to 10
Um,
come from?
Well, it was. It is in fact, I think, in paragraph 14 of the judgment. I think. Yes. Well, the second sentence, the importance of this, whilst hand sawing of AIBs is thought to generate between 5 to 10 fibres per milliliter. So that's it. And that was a figure that Ms. Conroy used as well. So you start off with 5 to 10. You divide that by 10, so it's 0.5 to 1.
And you divide it by 10, just spell it out because.
For the bystander, because he's
Yeah.
he's a few feet away.
And that Miss Conroy agreed with.
She agreed with that. And then you
Well, in fact, yes, I mean, she did agree with that, but it originally came into the joint statement.
yes, the calculation didn't, but I mean,
No,
that's right,
but the order of magnitude came in the
in
joint statement. Yeah.
You divide that by 10. Then you say, well, for a day, a working day's time-weighted average, you divide by you boil it down to the number of hours a day. So if it's 1 hour a day, it's 1/8 of that figure. If it's 2 hours a day, it's a quarter. And if my arithmetic is correct, then the figures just for being close as a bystander to the sawing activity would produce 0.062 to 0.125 fibres per milliliter. Now, of course, that wasn't the only activity, but that was one for which there was.
Well, hang on, that you say that because of the sweeping.
Yes, exactly.
Yep.
That activity.
When you say it isn't the only
I thought
activity,
this was from the hand sawing.
It is
Yes.
from the hand saw. Yes.
Yes.
This is his being close to that, or
The hand
in
saw.
the vicinity of
Yes.
hand sawing.
He mentions, without quantifying it, the possibility that some electric or mechanical sawing was done, but we
There's no
don't get any
evidence of that.
details of that.
Doesn't his witness say, I can't remember?
Yes, he does. Yeah. And then he has the sweeping, which he doesn't. He quantifies how often he did it, but he doesn't say much about what it was. And of course, we don't know how much of that was asbestos debris, as opposed to general building site debris that the plumbers or the other trades may have left. But you then have to add in this unquantifiable element coming from sweeping. Now, can I just take you to what Ms. Conroy was saying in her report as to what this activity might generate? She and her report for these purposes is at page 139 of the first supplementary bundle. We have something called the Asbestos Research Council in 1970 making some estimates for AIBs, this type of board. And their figures, dust concentration,
334.
yeah, well, 333, the first table,
Okay.
top of the page, brushing up dry, 19.4. There was only one test and one site where that's carried out. In fact, that's the least dusty activity. In fact, in some ways, in some circumstances, it's lower than the background test, oddly enough. And then in the next one, which is another publication by Turner Asbestos, ceiling panels. This is asbestos ceiling panels, brushing up dry 1.4. Again, only one test, and that was the lowest activity. In contrast, there was in the previous 137, there was the Red Road survey, which has been referred to, and the figure for sweeping up waste material was 37 fibres per milliliter. Ms. Conroy comments at paragraph 3.27 that no details were given of the measurement method, nor of the duration of samples. So how far that is, as it were, a snapshot or a time-weighted average remains unclear.
Sorry, which paragraph are you referring
That's
to?
the table at the top of page 137.
You were referring to the bottom of the one.
I'm sorry, yes, paragraph at the bottom of the previous page.
3.27.
3.27. No details are given of the measurement of duration of sampling. And the Red Road survey, the relevant document is in the second supplementary bundle, the engineering bundle, and starts at page 19, and it's May 1967.
Oh, give us a second to get that. So which page?
It starts at page 19.
Yeah.
And that date is important, of course, May 1967, because it's after the mesothelioma concern, and indeed they refer to it at page 29 under the heading Medical Viewpoint. From the medical point of view, the risks to health are from asbestosis or diffuse mesothelioma of the pleura or peritoneum. But going back to page 20, in their introduction, we are told why they're carrying out this survey, and it was several very large. This is the middle of paragraph, page 20. Several very large multi-storey flats are being erected at the previously mentioned building site. Complex arrangement of steel girders. Because of the risk of these structures twisting during the event of fire, the girders are required to be completely enclosed with asbestos products. In addition, the whole of the exterior of these buildings consists of asbestos cement sheeting. The girders and ceilings are all faced with asbestolux boarding, some of it amazite, some of it acetyl, and it's trimmed by means of a hand sawing operation, which visibly creates a considerable dust cloud. Then, the foot of the page, although a squad of men have apparently been appointed to the task of damping down and sweeping up the asbestolux sawdust as it is produced, no one was seen carrying out this task in any of the areas investigated. Indeed, in some rooms, the quantity of waste on the floor could easily be described as considerable. Only one man was seen engaged in sweeping up waste material, and this was being carried out in a room immediately prior to painting. No damping of the dust was. So this was asbestos products being applied on a huge scale to a substantial building, and we don't have the figures in here, they're in a separate document, but as I pointed out, this Conroy has extracted them and found for sweeping it was 37. So far we have a range of 1.4, 19.4, 37, and then finally she says at...
where's the 37 come from?
Well, that's in her report. She's derived
She
from
worked it out from somewhere.
material.
Remind me where the 19.4 is?
That's at page 139, which is the table at the top.
Yeah.
And I should just say, although ARC, Asbestos Research Council, was in a sense a manufacturer's lobby, curiously, as is commented by Ms. Conroy, in respect of their other measures, they are higher than some measures carried out by the factory inspectorate as set out in their technical notes.
It's rather a cynical view that it's because they may well be a manufacturer's lobby, but one would like to think that they didn't distort their figures.
Well, we would like to think that, but there
was a general perception that it was a manufacturer's lobby, rather than a disinterested.
Exactly.
Whether it was justified or not, it was quite a widespread perception.
But insofar as these figures may be said to be doubtful, the odd thing is that they come up with higher figures for the other activities than the factory inspectorate. The factory inspectorate don't have a figure for sweeping, so we don't have their figure. But then all we have beyond that is that at 3.42, page 142, this Conroy goes on to refer to an HSE guidance
Sorry,
book.
let's go back to the other bundle.
Sorry. Yes, we're finished.
Yeah, 142.
Well, so 142, paragraph 3.42, HSE guidance booklet, Introduction to Asbestos Essentials, published in April 2001, suggested a typical exposure for sweeping of AIB debris of up to 100 fibres per millilitre in circumstances of poor control measures and work practices. What is meant by poor control measures and work practices is not stated. However, in the context of sweeping AIB, this seems likely to me to be primarily mean dry sweeping. Now, the problem with that is that up to is like saying how long is a piece of string. Obviously, sweeping is not a precise activity in the way that using, say, a circular saw is, where you can expect to have.
And that is an accurate quote, is it? From
it is
from the guidance booklet.
We've got, it's not in the
No.
bundles.
If it is, it is. That's fine.
It's essentially a layman's guide. It's not. It gives no source for this assertion. It's merely a little table saying this is what to look out for. And but even taking 100, which is the very top of the range, way above some of the other figures that Ms. Conroy produced, just doing that same process on the judge's finding now, which is criticised, on the judge's finding of 10 minutes a day, that's 1/48th of an average working day. So even if he's in the breathing zone, so your 100 is then immediately divided by 48 to get his daily time-weighted average. Now, the judge, Mr. Cuthbert provided no figures for that, so the judge had to make some sort of finding. It's criticised as being far too low, but you would have to multiply that. You would have to have him for sweeping for a much greater amount of time to come anywhere near the sort of figures which even after 1960 would have exceeded threshold limit values. And so what these, to come back to what I was saying about paragraph 43 of the judgment, the 2 fibres per millilitre average, time-weighted average, is in fact pushing up quite a long way the figures that have been derived simply from being a bystander to the carpenters. And it would be impossible for the judge to be more precise. But the figure he comes up with, 2 fibres per millilitre, is 1/15th of what would have been considered the permissible maximum in 1960. And we say would probably have been the advice given if the factory inspector had been asked in 1955. Because I'm taking up my own friend's time, so I will now move on very quickly to the authorities. Visible clouds of dust are mentioned. There is nothing, there is no red flag in any of the literature about visible clouds of dust being something you should be concerned about, even as we've said when you get to the later literature which shows has photographs of people with no protection standing close to clouds of dust.
Is that right? I mean, we've surely seen plenty of references to visible clouds of dust in context which suggests that if you can see a visible cloud of dust, that is in absolutely general terms higher than if you can't see a cloud.
Well, I'm talking about the period, the 1950s. There's nothing in the guidance saying, I've already said, there's nothing about the construction industry business at all, but there's nothing specific about to say to the effect that, by the way, something else everyone should look out for is dust in the atmosphere.
So the submission is nothing in the literature to say that in the 1950s to say that visible clouds are a source of danger.
Yes. Okay. And the reason I took the court to those later photographs is that again we would say that a factory inspector in the 1950s wouldn't be concerned. Yeah. And so we say it's obvious that the inevitable finding that the Taylor Woodrow were not doing anything that was out of kilter with what the industry as a whole was doing, and was not acting contrary to guidance and so on. Very briefly on the authorities.
Before you leave that,
yes.
Paragraph 21(7) of the appellant's skeleton.
21.7
on page 20.
I'm looking at the earlier version, the paragraph numbering there.
Okay. Sorry. It's concession number 7
Thank you very much. This is yes, this is Dr. Phillips. If the V had made inquiries, the overwhelmingly clear message would have emerged that dust was dangerous, and they refer to page 66.
Yeah.
In fact, of the first bundle, the question was put in the middle of that page to that effect. If the defendant made inquiries and these documents had come to their attention, the message would have emerged that dust was hazardous and should be suppressed. Yes, I would agree with that. And then there's an argument. My own junior stood up and said, well, he's not an expert on 1950s standards. And as I took the court to yesterday, this ends up with, no doubt helpfully from the defendant's point of view, the judge asking the leading question rather than Ms. Foster. What Dr. Phillips can say and has said is that his understanding of what was happening in the construction industry at the time was that absent intense prolonged exposure, warnings and instruction were not being given and dust was not being suppressed. Is that right?
So sorry, where are you reading from?
Middle of 67. Letter C.
67.
Yes. So this is a continuation. It started off with one might say the bland agreement by Dr. Phillips that yes, it's hazardous.
Page 66.
On 66, but he goes on. The judge presses him about that.
So your responsive submission is he's not addressing the levels which you say were properly found by the judge.
Well, I would say that Dr. Phillips. Firstly, it's a question that is more submission than question for an occupational health expert. Of course, asbestos is hazardous. I mean, that wasn't in doubt. But the more interesting question is what was going on in the industry, and that's dealt with in answer to the judge on page 67. Dr. Phillips agrees with the proposition that warnings were not being given and dust was not being suppressed in the construction industry. In fact, there's a real question. The judge asked the question, so that's fine. But the real question is whether Dr. Phillips is qualified to comment at all. And we say the picture can be reconstructed by the contemporaneous material from the factory inspector and so on.
I don't think Mr. Platt's going to thank you if you start saying that occupational hygienists can't give evidence of this type.
No, that's true. But they do and they don't sometimes. But sometimes they can even though they wouldn't have been alive often at the time, they can talk about their understanding of the history of enforcement.
And they do it on the basis of documents which are effectively admitted as.
Well, I apologise in advance to my own friend Mr. Platt.
I mean, just looking again at 66.
Yes.
The initial answer. If you take this absolutely literally, Dr. Phillips is accepting, is he, that all dust should be suppressed?
Yes. Well, if you take it
limited to heavy and intense, is you suppress all dust.
Yes. Exactly, and he's doing what even Dr. Merriweather said is impossible, which is almost a prohibition on the use of asbestos. After all, we're talking about a construction site, so it's not easy to have mobile exhaust appliances where someone's just sawing up a board or somebody's having to sweep up. The witness said yes, trying to be helpful, but it's not, we say, something on which the appellants in this case can put before this court and say there's a concession from which the defendants would find the defendant. What I would say, because I've taken up a lot of time on the authorities, is really to focus on Jeremson, and I can do it very briefly because what we discover from reading Justice Hale's careful summary of the position in that case was, first of all, that she wasn't saying, as seems to be said in this case, something along the lines.
Tell us where Jeremson is to be found.
It's tab tab 12 in the Court of Appeal. I should say that my own friend Mr. Platt very helpfully in paragraph 84 of the skeleton set out the key findings of fact at first instance, and I won't repeat that, but it was heavy exposure. What is said is this in paragraph. I think we're almost. It's almost sufficient to go to this paragraph 40. The last three lines, the question remains whether the actual exposure found by the judge was such that the reasonable and careful employer taking positive thought for the safety of his workers would have identified enough of a risk for him either to take precautions or to take advice. So Lady Justice Hale certainly wasn't posing the question as being, is asbestos dangerous? And if so, did they take any precautions? Which is the simplistic way it seems to be put, we would respectfully say, in this court. And then we've seen...
That's classic stage one of analysis. That's have you given right to foreseeability?
Yeah, exactly. And she's dealt with foreseeability by reference to Stokes and GKN in paragraph 33. That's the introduction to this. And then going through the literature, we've seen paragraph 45, the reference to Dr. Merriweather's article. Bear in mind that although she's only quoting what the judge said about that, he quoted from part of Dr. Merriweather in 1933, not the whole of the article which we've looked at, but that was good enough for that case because it was a heavy exposure case. But what we get to importantly is in paragraph 53. This is the key, we say, to the whole case. Well, I should remind you of the end of paragraph 52. She says, about 6 lines up, the fact that other and greater risks emerge later does not detract from the power of what was already known, particularly as it affected employees such as these working in confined spaces containing a great deal of asbestos which might have been disturbed at any time. No reassurance in the literature. And then this is the key point in paragraph 53. If Shell had made inquiries, the judge was in little doubt what advice they would have received. And then she refers to the August 1945 Chief Inspector of Factories bulletin. He wrote to the shipbuilding and ship repairing industry of his concerns about asbestos insulation aboard ships, and which includes in the quote, if the workers are exposed to the dust in substantial concentrations, serious results are apt to develop later. Important, even if the work will be only temporary or reasonably practical, steps should be taken to reduce the minimum.
It's particularly if.
Sorry, no?
Well, you said if the workers are exposed.
Yes.
But in fact, what the quote says is particularly.
Particularly, yes, that's true. Interestingly, among the, and then it refers to the respirator for each workman engaged in the fitting or removal of a dry insulating material containing asbestos. And that that is the sort of warning from the factory inspector we don't have in this case. That's a specific warning given in August 1945 to the shipbuilding and ship repairing industry. And Shell tankers weren't necessarily in the building or repairing, but they were operating ships. And we lack anything like that in relation to the construction industry. And really that's all that this case tells us. It's not a departure, far from it, from the approach to the legal test for a duty of care and breach in the law of tort, and the use of Mr. Justice Swanwick's statement was later validated by the Supreme Court in Harland and Wolf. Then you bear in mind that's a defendant's appeal, a finding of a judge, as was Margerison, which we haven't looked at. That was the exposure outside of asbestos factory. Maguire, which is tab 14 in contrast, was a case where the defendant's appeal succeeded by a majority, but that was a case where the exposure was relatively heavy. Mrs. Maguire, Mr. Maguire worked for Harland and Wolff in the shipyard in Liverpool, and he was in the boiler room, and there was heavy exposure to asbestos, and his clothes were therefore heavily contaminated. And in paragraph 10 or 11 rather, the Mrs. Maguire described her circumstances, and she was shaking out the clothing, brushing them to get the dust off. The dust was everywhere. I shook the dust out of his jumpers and socks. I breathed in the dust when I shook it out. And so it was not a marginal exposure case by any means. Nevertheless, Lord Justice Judge, in paragraph 58, after referring to Marge Jerrison, said, in the second sentence, a family member is not precluded from establishing liability based on environmental contamination with asbestos dust because of Marge Jerrison. Then dropping down to the next but one sentence, however, in this case it was not established that the dust to which Mrs. Maguire was exposed effectively replicated her husband's level of exposure, nor indeed that her level of exposure.
Where are you reading from?
It's the
Paragraph
48, 3 lines down.
48, so
48, sorry. Third sentence.
It's okay, I have it now.
Not established that dust which Mrs. Maguire exposed effectively replicated her husband's level of exposure, nor indeed that her level of exposure to repeated in factory conditions would have constituted a breach of duty to an employee. So that's the only reason. It was not because of the remoteness of Mrs. Maguire as someone not employed by Harland and Wolff. It was simply the facts of the case that her level of exposure didn't reach the point where, even if it had been, she had been an employee, there would have been liability. Lord Justice Mance disagreed, and one of the things that, one of the reasons he disagreed was that Harland and Wolff seemed to have behaved outrageously in taking no precautions as a shipbuilder who really ought to know what was going on, and it was difficult for them to say that there was no liability. These cases must be looked at carefully in the context of the facts that this court is considering. And in our submission, they provide no assistance for a case of this sort. I won't go to Williams, which has been referred to.
Well, I think you're running out of time, aren't
yes,
you?
I'm sit down. I'm going to say about the ground 5 point.
Yes.
The judge's approach to this in paragraphs 24 to 42, I think, where he cast some doubt on some of the facts that were put forward, was, we say, impeccable. There's good reason why a defendant in these circumstances shouldn't seek to examine on commission or send Part 18 questions. It's not for the defendant to fill in gaps in the claimant's evidence. And in any event, in many respects, the judge's approach to the evidence was favourable to the claimant. And so we say there should be no complaint about his approach. And as far as sweeping for 10 minutes a day is concerned, well, no evidence was offered to the contrary.
Do you agree that the touchstone after TUI is fairness?
Yes, but it's clearly, as the exceptions acknowledged by Lord Hodge and TUI would encompass a case like this. There are practical problems. The courts all the time receive evidence, hearsay evidence, which can't practically be the subject of cross-examination. And to say that it is simply not the case that it's normal in a case like this for defendants, insurers to ask or even insist upon the intrusive process of seeking evidence on commission. Sometimes done, but it's not a regular practice in the submission. Otherwise, I've attempted to cover the ground. I'm sorry, I've taken a bit longer than I hoped.
Right. Thank you very much indeed. Yes, Mr. Steinberg. Didn't ask my lords if they have any. They don't. Right.
Well, may it please your lordships, I perhaps start with a confession I may yet be the characterised as the dangerous rebel that my learned friend Mr. Robinson so helpfully warned the court about yesterday. But I hope to assure the panel through my submissions that our case, the appeal in White, is based on established principles. My lords, the point of appeal in this case is narrow, relatively straightforward, and turns on the meaning we say of three well-known authorities from this court, those cases being Jeromeson, Maguire, and Bussey. And we say, grounding our appeal and our case firmly on those authorities, and confining them expressly to asbestos exposure, in an occupational setting, that by the time of the exposure in this case, the nature of the employer's duty had been established, namely to reduce exposure to the lowest level reasonably practical. And the central issue for the court is whether the judge was correct to assume, as he did, that there was an unspoken threshold which could be recognised, even if not quantified, to engage that very duty. My lords, it's also perhaps worth me stating at the outset that while the judge held in this case that the exposure was at a very low level in the first period, he did not find or purport to find that it was de minimis in any legal or technical sense. We fully accept that this is a liminal case.
What do you mean by a liminal case?
Well, my lord, it's near the borders of where foreseeability could be established. But we say on established principles it ought to have succeeded.
So the consequence would be any exposure which could have been avoided is a breach of duty at this time.
My lord, yes. My lord, yes, that's the primary submission, yes. The secondary submission, my lord, I will deal with it. Our secondary submission is that we say there's much force in what my learned friend Mr. Rawlinson says for the appellants in Cuthbert, that visible dust, which was known to include asbestos content, would be sufficient to trigger that duty. My lord, the judge set out the issues in dispute at paragraphs 4.2 and 4.3 of his judgment. Like others, I'll perhaps give you the references rather than take you to matters which probably aren't in dispute. That's it. The core bundle in our case at page 95, where he made clear his distinction between the questions of duty and breach. And my lords, at paragraph 6 on the following page, which is core bundle 96, he defined the central issue as whether the amount of dust to which Mr. White was likely to have been exposed triggered the duty to take precautionary steps. He decided the duty wasn't engaged, and his analysis follows from that proposition. We say that erroneous proposition.
Sorry, I didn't hear the end of that sentence.
Beg your pardon, my lord. His analysis starts from that proposition which we say was erroneous.
What's erroneous about it?
That there is
Even more
threshold.
vitally. Firstly, what is the erroneous proposition? And secondly, what's erroneous about it?
Well, my lord, the erroneous proposition we say is that there is this threshold, a certain
I see,
identifiable.
yes, okay.
And what's erroneous, as we say, that is contrary to the decision of this court.
You may quibble about the end or make submissions at the end, but at the moment, all he's saying is what's the level of exposure,
Yes, my lord.
and does that trigger a duty?
My lord, yes, indeed.
I think his error on your submissions comes later.
It does, my lord, it does. So the core point is expressed by a solitary ground of appeal, which is that the judge failed to apply what we say was the Jeromeson and Bussey approach to foreseeability. And that solitary ground of appeal is expressed in 6 different facets. And my lords, that appears at paragraph 43 of the appellant Scullin, and I will take those in turn in due course. The structure of my submissions will be in 4 parts. The first part will be an opening of the facts, a brief overview of the findings of fact that the judge made. Part 2 will be the nature and the evolution of the employer's duty which we contend. My lords, you've heard Mr. Rawlinson. I will not repeat what he has said. I will take, if I may, most of that as said already. Part 3, we will say that the judge and submit the judge was wrong drawing on those facets of the appeal. And part 4, my lords, time permitting, I will provide a response to some of the additional arguments raised by the respondent in support of the judge's reasoning. I deal with it in that way because these weren't factors that the judge relied upon, but certainly raised by the respondent. So if I may, my lords, the first stage is the findings of fact and the judgment of Mr. Hyam KC as it begins at Core Bundle, page 94. The findings of fact appear between paragraphs 16 and 20. Primarily, for our purposes, it's paragraphs 19.1 to 19.15 in relation to the first period of employment, and then paragraphs 20 Roman 1 to 20 Roman 11 in relation to the second, and page references are 99 to 106 of the core bundle. There is also, my lords, a summary, what the judge called a distillation of the key facts at paragraph 21, which is at core bundle 106. Now, Mr. White began working for the Sefton General Hospital in 1949 at the age of 17. He was employed as a junior lab technician from then until 1960. And after a period working elsewhere, he returned as a senior biochemist from 1973 onwards. He began to suffer respiratory illness in July 2019, and he was diagnosed with mesothelioma in September 2019. By the time he made his statement on the 27th of February 2020, he was gravely ill. He did manage to make some handwritten annotations, which the judge fairly acknowledged, but he died a few weeks later. This is not a case where we could reasonably contend that the defendants had a chance to take evidence on commission. At the trial, the claimants contended that Mr. White had been exposed in 3 ways. First, in the hospital lab during his first period of employment, from asbestos dust emitted from large protective heat mats, the types used under Bunsen burners. The judge held in that respect there was sufficient exposure to cause a significant increase in the risk of mesothelioma for the purposes of causation. My lords, that is paragraph 21, 1, core bundle 106. Secondly, again in the first period, from lagged pipework in the basement. Pardon, my lord.
Because of the 2 different perspectives, one the Fairchild perspective,
Yes.
and one what we're really talking about here. It's important that you said it's significant exposure, albeit you said it in the
causation
in the context
yes.
of causation. In fact, he says material.
Yes, material contribution to risk, yes.
I picked you up on it, but there's no distinction between what you were saying.
No,
and what
no.
I just
Sorry, it was unintentional, my lord. I take the point. The judge held in relation to the visits to the hospital basement where there was lagged, there was no significant exposure from that activity. It's paragraph 19, Roman 13. That's at 102, and that isn't challenged. And thirdly, in the hospital lab, in the second period, from the mats which were then in use. And the judge held in that period they were more likely to be hard mats than soft mats. And so, as a result, there was no significant exposure in this period. That's paragraph 21, 2, page 106. Again, that's not challenged. Now, there was no oral evidence in this trial. It only lasted a day. And the evidence before the court was simply the statement of Mr. White himself, including his handwritten annotation, the statement of his daughter, Emma White, which didn't take the allegations any further, and the report of Dr. Hewson. Now, my lords, in a certain sense, the judge treated that expert evidence almost as a general purpose evidence of fact. But by way of example, what I mean by that is Dr. Hewson felt able to offer an opinion as to how often the mats would have been moved or broken, or how often the surfaces were wiped in the proximity of Mr. White. He held that was suggested it was 4 times a day. And the judge accepted that evidence on the basis that Dr. Hewson had had experience himself in labs. Now, from 1981, my lords, while the appellant isn't totally comfortable with the judge's approach, we don't challenge any of that. We appreciate and accept that the judge was in a difficult position. And we say that the error lay elsewhere, in fact.
But his experience goes a long way back. It doesn't go back to the period we're concerned with.
Mm.
But for example, his evidence about the likelihood of mats being moved from underneath the existing position under a Bunsen burner is based on his experience going back to the 70s, I think.
I believe he started in 1981 at IOM. His CV is at page 121 of the supplementary.
But the point I'm making is that he's not expressing an opinion on the basis of the documents. He's extrapolating back from his own experience.
He is. Oh, yes.
And as you fairly said, you don't challenge, but that's not an objectionable approach for someone with his level of experience and expertise.
Well, my lord, as I said, I don't challenge it. I don't wish to make too much of it, but he's talking about laboratory conditions before he was born. If we were mounting an appeal on that basis, I would certainly be drawing the court's attention to that, but we're not. In any event, in evaluating the alleged exposure, the judge considered it necessary to decide whether they had been using hard or soft mats in the laboratory. And the judge made a number of findings, and I would like to highlight 5, if I may. The first, at paragraph 19.9, that's at page 101, that the mats used during the first period of employment were likely to have been the soft mats, soft material. Secondly, at paragraph 19.10, it's at page 101 also, that they must have either been AIB or asbestos millboard. And of those 2 possibilities, they were slightly more likely to have been millboard. Thirdly, further on in that same paragraph...
So the finding actually is millboard.
Millboard, my lord, yes.
Yes.
Further on that same paragraph, he held, in the light of Dr. Hewson's evidence, that such a mat would have, he said, a high asbestos content and low density. So it was quite easy to break, and the surface was subject to abrasion and wear. That's paragraph 19.10. Fourthly, in the same paragraph, he appeared to accept the evidence of Mr. White in this respect, that the mats had been very fragile. They would simply break and the edges would be flaky. If you placed the board down onto the desk heavily, it would just break into pieces and cause so much dust to emerge from the same. And fifthly, if it was millboard, and I love the Vice President, it's correct, that was the finding, prior to 1965, then it may have contained crocodylite, i.e. blue asbestos, and the composition of millboard, Dr. Hewson reported, would be up to 97% asbestos. That isn't in that paragraph, but my lord, the reference is the supplementary bundle, page 32, paragraphs 4.3.20. 4.3.20, 32.
Actually, as a finding, it isn't a finding that it is crocodylite. The finding is it's possible that crocodylite was possibly used.
Yes, there was a.
Sorry, which paragraph is that?
Well,
It's 1910. I mean, I understand why you're spelling this out, but the facts are pretty clearly found and show that there was, which is all you need, a possibility
yes,
of these mats generating asbestos dust when
Yes.
broken or flaky or in other use. That's it, isn't it?
well, I guess I'll move on in that case. But an important point that arises from that, Mo, that same point, is that throughout the relevant period, there was another type of mat available, the hard mat, whereas the soft mats were friable and prone to fraying. The hard mats, according to Dr. Hewson, wouldn't have given off asbestos dust that was greater than background.
But again, I'm not in any way trying to hurry you up, but I mean, that's not really the issue. Nobody's suggesting there wasn't any alternative. The issue is simply, given the mats that were used, was there a foreseeable risk?
Well, my lord, yes, I'm prefacing that because my point will be in terms of reasonable practicability.
Yeah, but there isn't any issue about that on the appeal, is there?
okay.
So, I mean, I'm all for you laying out your case, but actually we want to get to the issue.
Well, I will move on. In that event, my lord, may I turn to the? I hope this does deal with the issue.
Okay, no.
We'll see. My lord, 1907. We're in the same territory, page 100.
Is this one of your 5 findings?
No, it's not. I've moved on. I've
Yes,
taken
okay. No, 1907, yep.
1907. This is where the judge cited a memo from the Department of Education and Science that was issued in 1967. By 1967, the schools were being advised that hard mats should be used in preference to soft mats. My lord, it is quoted, cited by the judge at page 100. The reference for the document itself, if the court wishes to consider that, it's in the White Reference Library at tab 25. The PDF number is 366. The page number is 664.
Sorry, give me, so it's tab 25.
PDF 366 or hard copy 664.
664, thank you.
But you're not asking us to go to it.
Well, my lord, I was simply going to take it from. Well, perhaps.
No, we don't. I don't want to be taken. I just wanted to know whether we're getting it out.
Well, the reason why.
It's all set out here, at least, unless there's a further part you want us to see.
My lord, there's a minor typo.
Okay, well, whatever you.
In the paragraph which begins in circumstances, in which the third line down, there should be an or between asbestosis and cancer, but I think that's obvious from.
Okay.
Well, what we see from this is that from the first paragraph, it said that in circumstances in which asbestos is used in school, there would seem to be little, if any, risk of creating such heavy quantities of dust as to cause either asbestosis cancer of the long and later years. Even so, inhalation of any form of asbestos by pupils and teachers should be reduced to a minimum. My lord, that paragraph is a specific reference to asbestosis and not mesothelioma, because the reference to mesothelioma comes in the next paragraph, where it is said the occurrence of mesothelioma is associated especially with products made from the naturally occurring forms of asbestos, crocodylite, and exposure to even lower concentrations of dust may be hazardous. And then in paragraph 4, my lords, we see the specific precautions that were advised, which essentially was to remove and substitute the hard mats for the soft mats, and to replace if they became frayed. Now, what the judge inferred from all of this was that soft mats were in widespread use in schools before 1967.
I'm in real trouble. I've turned I've turned my hearing aids up. I'm still having trouble.
I'm sorry,
catching
my lord.
everything.
I'll try and keep my voice up. I apologise. What the judge inferred from all of this was that it showed that soft mats were still in use in 1960 in widespread use. We say that there were other obvious points from this document. And I appreciate I'm projecting backwards, but we can see here in 1967 that when the Department of Education had turned its mind to the question, it expressly recommended the application of a precautionary approach. As is clear from the face of the document, the warning, the recommendation to reduce asbestos to the lowest level practicable was made in relation to asbestosis as well as mesothelioma.
Isn't that reading a bit too much into it?
Well, my lord, it's in the same paragraph. The document itself delineates the three different conditions.
Yes, but it's just the structure. We may have to look at it, but I think it's clear enough for this. The structure of the passage is here are the risks, and then it moves on to what you should do about them in para 4, isn't that?
Well, my lord, yes, but also in the second paragraph. Perhaps it might be easy if we look at the document itself, just very briefly. It's 366 in the PDF.
It's tab 25 in volume 2, I think.
It's 664.
Just give me a moment to. It's very short. I bet I didn't read the whole thing. You can see the structure. Yep.
So, my lord, I of course take the point that paragraph 4 certainly relates to the, if one likes, the total possibilities, the three conditions. But paragraph 3, where it is stated that even so, inhalation of any form of asbestos dust should be reduced to a minimum, relates back to asbestosis and the association with lung cancer. My lords, that advice from the Department of Education by 1976 hardened into effectively a prohibition, but too late for my purposes.
67 this is, isn't it?
My lord, yes. So, having concluded that the heat mats during the first period were probably asbestos millboard, the judge went on to consider the level of dust to which Mr. White would have been exposed as a result. And my lord, I'm mindful of the discussion yesterday of adjectival descriptors, and I'll try not to get too deeply involved in that, but there were qualitative findings and quantitative findings. The qualitative findings are set out essentially in paragraph 19, Roman 12, at 102. And my lord, I have, how many do I have? I have 6 here, if I'm permitted to go through them.
6 what? 6 points.
Six physics findings of a qualitative nature. At paragraph 1912, he rejected Mr. White's direct evidence that the benches would be covered with asbestos and there was a constant flow. So he rejected the high point of what Mr. White had said, principally on the basis of Dr. Hewson's evidence. Secondly, he found instead that the abrasion of the mats by normal usage would be likely to cause small amounts of dust to be emitted. Thirdly, he held that some dust would be emitted when the mats were intermittently moved around the laboratory.
So what was the second finding?
I beg your pardon. The second one was that the abrasion of the mats by normal usage would be likely to cause small amounts of
Sorry, yeah. Thank you.
dust in it. Well, I perhaps could have grouped these in one or two, perhaps, rather than breaking them down, but forgive me.
It's a bit over the top, but yes, okay.
Okay.
I'm afraid I didn't catch your third one.
Some dust would be emitted when the mats were intermittently moved around the lab.
Yeah.
The fourth one is that the lab benches would be wiped down regularly, which would cause dust to enter the work environment. And I just pause there to say that necessarily implies we say the presence of visible asbestos dust.
Does it?
My lord, yes. What else would they be wiping down?
Well, they will be wiping down the surface. Whether that would create a cloud of visible cloud, which
I wouldn't go so far as to say a cloud.
oh, I see.
I have to say it's visible dust on the benches.
Yes, I see.
That's the context of that paragraph.
Is that right in a laboratory where cleanliness is everything?
Well, my lord, there was no real evidence about.
It's a laboratory.
Well, it is a laboratory, my lord, but there wasn't any evidence before the court as to the state of this laboratory other than what Mr.
Yeah,
White.
No, but there's no evidence that wiping up was of itself indicative that asbestos was visible.
Well, no, I submit from that paragraph taken hold that is what he was talking about.
Okay. Because you're still relying on 1912 as the judgment, aren't you? You in 1912?
Yes,
Yes,
we're on 1912. Keep going.
Forgive me. Occasionally, the mats might break up and emit larger quantities of dust.
Yeah.
Again, I say he must be talking about asbestos dust. And generally, however, the emission of dust was intermittent and at low quantities. The quantitative findings.
Yes, I mean, I don't want to be picky, but those are quantitative findings at all. They're just not figures that are attached to them.
Possibly, yes.
Yeah, okay.
The quantitative findings, perhaps more accurately described at 19 Roman 15 at 103. He found that the dust would be released by mats from abrasion when they were moved or dropped because they were flaky friable. And as a result, Mr. White would be exposed to asbestos dust when he moved or dropped the mats himself, when he was in close proximity to others who.
We can read it. What's the particular point you're getting from this? I mean, we have.
Well, I'm not. I was going to move to the concentration, so that's it. Further on, the concentration of the airborne dust was around 1 to 2 fibres per milliliter in those moments, in those times, and would persist for 2 to 3 minutes.
Sorry, I haven't kept up with you. Where are you reading from?
It's again, we're in paragraph 1915.
Which bullet?
It's the it's the first bullet point.
I see. Yes.
I
Being
apologise.
slow. The last thing you said gave some figures which I can't find in the first.
Yes,
bullet.
well, if you look at 1915,
Yes, as I'm looking at it.
the first bullet point.
Literally
is
the
handling
first
of-
sentence.
Yes. The handling of a friable form of asbestos, such as millboard, would likely create an asbestos dust
Yeah.
concentration
Yeah.
of 1 to 2.
Yes.
My lord, he held that Mr. White would be exposed to such concentrations for around 12 minutes per day, working on Dr. Houston's estimate. That's further down the same paragraph, where it begins in terms of actual periods of emission.
Yeah.
Still in the same paragraph, the next bullet point, that on days when the heat mats were used, the 8-hour time-weighted average would be 0.02 to 0.05 fibres per milliliter.
Yep.
And then finally, his cumulative exposure over this period of time would be 0.2 to 0.4 fibre milliliter years. It's the overall dose. So the judge's overall conclusion was that the exposure in the first period was likely to have been modest and infrequent, and in overall terms, not more than minimal. That's at page 103 as well. Beg your pardon, it spills over into page 104.
Yes.
Forgive me.
Yeah, don't worry, we read it. Where do we go now?
So, my lord, I will return to the way in which the judge assessed that, but I simply say it wasn't a finding that this was de minimis. I don't believe
It wasn't a finding that
it was a technically or in any legal sense it was de minimis.
What's the distinction between minimal and de minimis?
Well, my lord, we see it. The judge makes it himself in relation to the second period of exposure. The important point I take from it, my lord, is that he was talking here in terms of overall exposure. The dose, he said, was not more than minimal. You can see, my lord, a different approach when he talks about the exposure during the second period. And so that if I could take your lordships to paragraph 20, paragraph 8.
Just hold on a second. Sorry, I'm just looking for something.
Well, if it is this, there's no dispute that this isn't a de minimis dose.
No, well, I rather-
Otherwise, you'd have no cause of action.
Well, my lord, that does assist. My lord, with that in mind, can I move on then to the second part of my submissions?
Yeah.
Which is the evolution and the expression of the employer's duty of care. My learned friend, Mr. Rawlinson, has taken the court through the literature, and I won't do the same or repeat that exercise. I will say I endorse respectfully and adopt what he says in relation to this appeal as well. The judge himself started with the well-known passages from Stokes and from Thompson and the ship repairers. My lords, for your note, it's paragraphs 22 and 23 of the judgment, pages 106 and 107. And he then considered the other authorities dealing more specifically with asbestos. And he expressed the duty of care at paragraph 42 of his judgment. That's at page 113. He says, I start with the overall question derived from Jeromeson, 35 and 52. That is whether the risk of personal injury arising from this exposure to asbestos ought to have been reasonably foreseen by the careful employer, to the extent that the employer should have taken precautions, or at the very least sought advice as to what precautions he could take. And my lords, in paragraph 43, he stated that he was to follow the two stages of inquiry laid down by this court in the case of Bussey. And this was necessarily a summary of his approach, and we don't criticise how he describes his task, but we simply say in the context of asbestos exposure, the duty on the employer has been refined and shaped effectively by years of litigation. That specific duty is an expression of the wider duty of care, and we don't contend that some special law applies to asbestos, but we do say it has some additional features that this judge didn't take into account, coming from Jeromeson. So, my lords, can I turn to the grounds of appeal in that event? In the light of the Court of Appeal cases, I say Jeromeson, Maguire and Bussey, we say the position at common law can be summarised by the propositions set out at paragraph 42. My lord, they are 5.
Paragraph 42 of what?
Sorry, of the appellant's skeleton argument. Forgive me. Firstly, by the early 1950s, it was known with certainty that asbestos was dangerous. Well, there's no need to go to this further unless you wish to do so.
Well, I was just saying to listen with it in front of me, so
Forgive me.
otherwise I'll have to write it all down, and then if you say anything different or anything more emerges, I'll mark it up. Yep.
Well, the first one was that by the early 50s, it was known with certainty that asbestos was dangerous. Secondly, by contrast, there was a complete and acknowledged absence of any knowledge as to what might constitute a safe level of exposure. Thirdly, even if had such knowledge been available, there was no reliable means of measuring the concentration of asbestos fibres in the air at this time. Fourthly, in the light of such ignorance, a prudent employer could not safely assume that the employees would never be subject to sufficient cumulative exposure to cause injury or brush off the risk as far-fetched. And fifthly, instead, it was the default duty of every employer to reduce their employer's exposure to the greatest extent reasonably practicable. What that required would be fact and context specific, but the nature of and the scope of the duty was constant. My lords, I don't go to the sixth one. I'd listen to what I'm saying. The appeal turns on what we say was the judge's failure to follow that structure of those propositions. And the grounds of appeal identify what we contend to be 6 errors. But the overall point, the unifying theme is that the judge was wrong to decide that there was some specific threshold to engage the defendant's duty. Our primary submission, essentially, is that anything above a de minimis level was sufficient to trigger that duty. As a secondary submission, we agree with the appellants in Cuthbert that the presence of visible dust known to have an asbestos content would certainly be enough. And my lords, on that approach, the trigger for the duty would be the employer knowing that there would be asbestos dust in the air. That might be because they could see the dust, as in both of these appeals, or alternatively because a soft, friable material like millboard had a high asbestos content and would obviously be dusty. A useful contrast can be made, we say, for example, with the lagging in the basement, which if in good condition and undisturbed wouldn't emit dust. Or similarly, the hard asbestos cement mats Dr. Houston said if they had been used, then they wouldn't give rise to a significant level of dust. But essentially, either way, in circumstances where the defendant had set Mr. White to work on an almost daily basis with friable and flaky mats that were prone to emit dust, we say that the judge was wrong to find that there was some additional threshold. Can I turn with that to the first point of the appeal, which is that when considering the question of foreseeability, the judge considered the actual level of Mr. White's exposure rather than the potential maximum exposure, which we say we derive from Johnson. At paragraph 6 of paragraph 26 of the judgment, which appears at page 108, the judge considered the Joramson case, where counsel for the defendant shall contended that the court should consider the average exposure over the relevant period, and the judge cited the relevant passage from the decision of Lady Justice Hale there. she held, and my lords, I can pick this up actually from the decision itself, in the quotation between 26 and 27, really just the final sentence. Only if he could be reassured that none of the employees would be sufficiently exposed to be at risk could he safely ignore it. And so we say what this demonstrates, considering Jeromeson as a whole, is that the employer, and by extension the court, is required to consider the worst case scenario, the maximum potential exposure. And the judge framed the question in the terms we see at paragraph 42, it's 112 of the judgment. Forgive me, paragraph 42 it's not 112, it's, yes it is, sorry, it's 112, paragraph 42. He said, I start with the overall question derived from Jeromeson at 35 and 52. That is whether the risk of personal injury arising from his exposure to asbestos ought reasonably to have been foreseen by a careful employer. My lord, we don't quibble with that, save that the judge didn't then go on to identify what the maximum possible exposure would have been, which we say is the key question to whether or not there was this duty. He didn't consider, for example, the possibility of someone spending considerably more time than the average estimates of Dr. Hewson, or the possible effects of mishaps, or failure to replace frayed mats, or the consequences of somebody working in those conditions for a working life.
This is an impressionistic question. Do you submit that the maximum exposure to asbestos in this case is qualitatively similar to the levels of exposure that was understood to give rise to a material risk of asbestosis?
My lord, on that point, I simply say that was an unknown for the reasons that Mr. Rawlinson took you to yesterday. It was quite clear that higher levels of exposure, what Lady Justice Hale calls the shocking news, will result in asbestosis. But the lower end of the scale simply wasn't known.
If we were to find, despite that submission, that the general understanding was that asbestosis was a consequence of heavy exposure, typically as found with laggers, process workers, people emptying dusty bags, and so on and so forth, sort of the classic, typical heavy exposure. Are you submitting that the maximum levels of exposure in your case are qualitatively similar, because we're not dealing in quantitative assessments, but qualitatively similar to the exposure that would typically be experienced by the lagger, the person stripping asbestos, the person mixing asbestos in a bucket?
Well, I was in qualitative terms. I don't say we are in that category, obviously, but I say in qualitative terms, the maximum potential would have been enough to put the employer on notice that it could make a material contribution to the disease. Might not be enough to be said to cause it at this stage, because it simply wasn't known, but it could be enough at its highest, at the potential maximum, to make a material contribution, this being a dose-related condition.
And you've deprecated the suggestion of thresholds, but I think your submission goes further than that, and is that any exposure is enough to put an employer on notice during the relevant period.
Yes.
Anything
beyond de minimis, yes.
Right.
So to be clear, if we're looking to whether the employer foresees a risk, do you say an employer should have foreseen a risk at anything above de minimis? Or is it rather that you say the employer should have foreseen that asbestos in general could be dangerous, and if you don't know what the danger is, you should take a precautionary approach?
My lord, it's closer to the latter. Simply because there was a state. What was known was that it was dangerous, but other than that, there was at the lower end a complete state of uncertainty.
So it is, you're not saying that at the lower end, just above de minimis, it was foreseeable that there would be injury.
My lord, if I were to refine my position, I would say it's foreseeable that there was a potential, a risk. Yes, I would say.
But in that case, on the classic, sorry,
Please.
on the classic formulation of when a duty arises, the first thing with the sort of trigger that you're talking about is what would the answer have been if they'd gone and asked someone what to do? And here we've got the judge's finding, which you do not challenge, that if they had asked, they would have been told that these levels were okay.
Well, my lord, that's the regulatory response argument.
It's the response of the common law, or it's the test laid down by the common law for when a duty arises. If you and I'm assuming in your favour that any exposure can act as a trigger, in the sense that an employer should say, I don't know. Then the touchstone, or a touchstone for the existence of a duty, is what would happen if you went to relevant, suitably qualified people. Mr. Rawlinson quibbled with, took me to task about the factory inspector, but it doesn't matter who it is, the suitably qualified person. And if the suitably qualified person would say, not a problem, no duty.
Well,
and if you go, sorry, let me just add,
forgive me.
the reason why I'm pressing on this is if you go beyond that, you go from the common law test for the existence of a duty straight into the precautionary principle, which is different.
Well, my lord, do you have in mind there the precautionary principle as applied in say, EU law?
As applied in European law.
Yeah. Well, my lord, can I deal with that point, if I may? In that context, the precautionary principle, I would submit, applies where scientific evidence about a particular step, a particular hazard, potential hazard, is inconclusive and uncertain, and there are reasonable grounds for supposing that there may be some harmful effects. Well, that's, as I understand it,
So by that stage,
I'm very close to the edge of my knowledge. Well, my lords, I say it's different, the precautionary principle, as applied and certainly in the EU law, because in this situation, we have not a possibility of harm, but a recognition that this substance is dangerous, and the only uncertainty surrounds the extent of that danger. And so, in a part, I say that the 1967 memo is an answer to this, because by 1967, with no advance in the state of knowledge, the Department of Education was saying it's wise to reduce to the lowest level reasonably practicable. And part of that was to remove the hard mats. Now, my lords, I accept, of course, that's post-mesothelioma. But the second part of that document was clearly by reference to paragraph 2, which referred to asbestosis. And my lord, we can then go to Jeromeson, and perhaps it might make sense to do that now in an attempt to answer this point. Perhaps first at paragraph 37. Forgive me, it's in the authorities bundle. learned friend tells me. Page 421 of the authority, paragraph 37. Mr. Mackay, on behalf of Shell, argues that where the issue is whether any risk at all should have been identified.
Which paragraph?
I beg your pardon, my lord, it's 37 on
37, thank you.
it's more appropriate to consider whether the average as opposed to the potential exposure was sufficient to ring the bell. However, where an employer cannot know the extent of any particular employee's exposure over the period of his employment, knows or ought to know that the exposure is variable, and knows or ought to know that the potential maximum as well as the potential minimum, a reasonable and prudent employer taking positive thought for the safety of the workers would have to take thought for the risks involved in the potential maximum exposure. And this is the important bit actually for my purposes, only if he could be reassured that none of these employers would be sufficiently exposed to a risk could he safely ignore it.
That can't be read apart from the whole paragraph, and the point being considered. This was a case where people were working in a situation where there was a high degree of exposure, but in order to measure it, but the high degree of exposure, but it was variable. And the question was simply one of method, whether you should look only at the average or look at the peaks.
My lord, yes, but
Am I not?
no, my lord,
I
I accept that, of course, but that was the contextual, that was the findings in that case. But I say,
but that was also, sorry, I don't want to interrupt you, but just so you address the point, that is what Lady Justice Hale was addressing. And you shouldn't read more into it than her answer to the point that she was addressing.
well, my lord, I certainly don't intend to do that. In my submission, it's unqualified. I accept the factual context, of course.
I mean, take it on an unqualified basis. Why should it be so? I mean, if asbestosis is thought to be related to the cumulative build-up, why do you worry about the potential maximum rather than the average?
Well, my lord,
I mean, is there any reason to believe that a peak of itself is dangerous as opposed to the cumulative?
my lord, no, the etiology was unclear. My own friend has spoken about yesterday. My first point really simply is that there was a range of unknowns, the variables. Essentially, I rely upon both the ruling of Lady Justice Hale and the reasons which she gives underlying it. And we say it's less about the specific causation requirements of asbestosis, but how and why the duty arises. Because any substantial employer might have a number of employees and doing all sorts of different things. And one of the features of Shell was that there were different engineers. Jermson, sorry, but they have to consider the worst case scenario when constructing their and devising their system of work, because of the uncertainties that surround us. And most the danger is in using hindsight. This has to be assessed prospectively, because at the time the employers don't know what's going to happen. They didn't know how long Mr. White would work. They don't know whether he would do other jobs that involved exposure to asbestos. And because it's dose related and because it's possible to make a material contribution in that way, we say that's why the duty is expressed in this way. And that's why the courts are.
I wonder whether I'm looking at it again, whether I've mischaracterized what the point was that the judge was dealing with. Reading it with 36, was it actually a point about a given person working over a longish period, whether you look at the peak exposure in bits of that period or the average over the period, which is vulnerable to the point my lord makes about it. Or rather that, given that the conditions varied from time to time, particular individuals might go in at a peak period and not at a low period. So no question of averaging arose in their case. It was simply a question of whether the time that they were exposed was one of the times when a great deal of asbestos was being given off. As I say, that's not how I read it first time round, but this is the advantage of oral advocacy. Looking at it with para 36, that actually is the point, isn't it?
Well, my lord, I'd qualify that by saying at 37, Lady Justice Hale says that, however, where an employer cannot know the extent of any particular employee's exposure over the period of his employment, knows or ought to know that the exposure is variable, and knows or ought to know the potential maximum as well as the minimum. So it's the particular employer working in different environments.
So is that not consistent with my lord's point? You have to take account of the fact that while the average employee might not have any particular exposure, the particular employee might have a greater exposure, and you have to look at the maximum exposure that the particular employee might have.
Well, my lord, in point of fact, I would respectfully submit it doesn't make a great deal of difference in this case because we're still looking at the potential.
Well, it may or may not. We've got to interpret what Lady Justice Hale had in mind when she made that rather general statement.
It does make a difference because the submission, certainly that was being made yesterday, was that if you take the potential duty to an individual employee, you shouldn't take the average loading over a period. You should take the worst loading that he might face. And it was being put to us on the basis of spikes. And I was querying yesterday why, and my lord's questioning again today, why spikes matter when you're dealing with a divisible disease where it's the cumulative load that matters. And hence my lord's question, is there anything special about a more intense exposure that means that that is qualitatively different in causative terms? And
my lord, not that I was aware, it was an unknown, I think.
I would respectfully agree with that. So the formulation that we've been investigating for the last couple of minutes does matter to that argument that was being put forward yesterday.
Well, my lord, Lady Justice Hale was considering the judgment of the court below, and it might be helpful to have a look at that briefly. If one turns to page 364.
Hold on. Please. What page are you on?
I beg your pardon, my lord, page 364 in the authorities bundle.
Thank you.
This is the decision of Mr. Mackel, QC as he then was. And under the findings of fact, this third line down, he says, I was at first attracted by the argument of Mr. Mackay, QC, on behalf of Shell, that I should assess average exposure, but ultimately I've been persuaded by the arguments of Mr. Allen, QC, on behalf of the claimants, it is more appropriate for me to address my findings to the question of potential exposure. Mr. Allen based this argument upon the great variety of experience of individual engineers, which was such that in determining what precautions he ought to take, a careful employer ought to have regard to the exposure which an engineer could experience. It would be impossible in advance to determine an average for any given season, and the evidence in this case demonstrates that fact. And I say that
should the emphasis be on the could? A careful employer ought to have regard to the exposure which an engineer could experience.
So perhaps also on an engineer.
Well, my lord, yes, I respectfully say that brings us back to the point that I made, which is that you focus on the potential for this employer and what the maximum was.
But that's not peaks. That's looking at the potential total exposure.
My lord, yes, it is.
And I
It's
think
not
it's
really
clear,
smart.
in fact, from the reference to the great variety of experience of individual engineers, that I think my rereading of it, which perhaps everyone else has read from the start, but I'm not sure that was how we were looking at it yesterday, is right, that the argument being advanced, the approach being taken by Mr. Michel, or Machel, however he pronounces himself, is that you have got to see what the experience of a particular person might be, not what the average of the workforce as a whole would be, rather than a distinction between different between pizzas bites in a period of one person's exposure.
Well, my lord, yes, but in considering that person, it's you have to consider their potential maximum.
Yes.
Well, that's really as far as my point goes.
Okay. Well, I think we've probably explored that enough.
Well, my lord, I was considering the judge's approach to this, and my submission, and I maintain my submission, is that he did fail to consider the potential maximum exposure of this employer. And
This employee.
Sorry, this employee. Sorry. And at 1915, paragraph 1915 of his judgment, which is at 103 to 104, the judge considered Dr. Hewson's back calculation and said he'd been persuaded by such evidence that the likely level of exposure during this period was modest and infrequent, and in overall terms, not more than. I suppose to deal with the points that have been put to me, I say there was a flaw in that. There was a flaw in that approach. When the court was considering, did this create a duty? Firstly, working from that estimate of the likely exposure, essentially relies on various forms of hindsight. The overall dose is a product of concentration and length of exposure, and the hospital at the time couldn't have known either. They didn't have the means to measure, and they wouldn't know how long Mr. White would be working. Secondly, although the judge was entitled to rely on Dr. Hewson's estimates of the average.
These are all parts of your first point.
My lord, yes, they are.
Yeah, no, fine.
I'm attempting to respond to the.
No. I just wanted to get my structure clear. Carry on.
Although the judge was entitled to rely on Dr. Hewson's estimates of the average and cumulative, they were. My lord, I don't criticise this. They were necessarily based on various assumptions and variables, and Dr. Hewson himself fairly accepted the inherent imprecision in that exercise. My lords, for your note, if you desire it, it's at paragraph 5.3.9 of the supplementary bundle, page 42. He said the airborne concentrations would most likely vary from day to day and week to week, depending on the condition of the Bunsen burner mats and the workplace-related factors such as the level of activity and ventilation, all of which remain unknown. He accepted it wasn't possible to provide an accurate estimate, and added the cautionary note that his figures were associated with a high degree of uncertainty, as he called it. My lord, it was perfectly proper of Dr. Hewson to highlight the difficulties I had, and I don't criticise him for doing so. Well, we say that the dose estimate was reached on the basis of what Dr. Hewson knew in 2022 when he made his report, not what the hospital would have known when they started employing Mr. White. And well, just at the risk of being repetitive, just to remind the court what the judge's findings were about Mr. White's exposure. It's that the soft mats would have a high asbestos content low density, so they were quite easy to break. And he held, or seemed to hold, that that was consistent with Mr. White's evidence, that they were very fragile, that they would simply break at the edges and release so much dust. So we say the key points are it's very fragile, it's flaky, it's prone to release so much dust. And that is what the hospital would know in 1949, not concentrations in fibres per milliliter of air. They are the things that they knew or ought to know. And if that's what the employer knew, which was ultimately the British state, that asbestos was dangerous, that it could cause fatal disease over a long period, and that there was no safe lower limit. My lords, can I move on to my second point? Perhaps I spent, I think, long enough on that one. The second point is that the judge approached the literature from the wrong direction, asking himself whether there was evidence that the level of exposure was hazardous, rather than whether the hospital could be reassured that it was safe. And the second point, we say, compounded the first error, because the judge asked the question from the wrong direction. The correct question, we say, applying what we maintain as the precautionary approach mandated by Jeromeson, was to ask whether the employer could be.
Well, this is really just the same point you've
Well,
already made, repackaged.
Repackaged.
I'm not being
No.
critical, but I mean there is a risk that when you grind this small, you ultimately make the same point again.
My lord, yes. My lord, well, can I wrap that up and if I may, and simply say that the respondent in this case and in the Cuthbert appeal warned the court of the danger of extracting particular words and phrases and taking them out of context. It was Mr. Justice Mustall's phrase in Thompson, a flood of literature. My lords, in Jeromeson, counsel for Shell had made the exact same point about the same documents on which we rely in this case, but nonetheless, what Lady Justice Hale said at paragraph 47, my lords, the reference is 423, was that what the Chief Inspector of Factories had said in the annual report of 1938 was a potent description of asbestos dust. It's on page 423. It's the ending remarks in paragraph 47. My lord, we simply say that was not just an acknowledgement of what the trial judge had found, but on its face it appears to be an endorsement of what he found, having considered the literature. And these documents weren't obscure publications, they weren't esoteric journals read by a few experts. All of this was clearly said, we say, in the annual reports of the factory inspector.
Just pausing briefly, in the quotation there's reference to substantial quantity of dust.
Yes.
The evidence here doesn't show substantial quantity
Oh
of
no,
dust.
it doesn't. It doesn't. But the part on which I obviously rely is the last sentence. It's not many years ago when the dust of asbestos was regarded as innocuous, while today it's recognised as highly dangerous. Lord, I say that's not said by reference to any particular quantity. It's just an understanding that this was a dangerous material used in the workplace.
Yeah, Well, it's the known unknown point.
It's the no, my lord, it is, and I'm probably labouring it too much, but we say that there's nothing in the literature that could have reassured any employer, let alone a public body. And that brings me back, I'm not going to go back there, my lords, but to paragraph 37 of Jerome's. And we say the judge's decision that this employer had no duty to reduce the exposure was an error, but regardless of that, it didn't follow the logic of this case. And we also say that the position was explained by the Court of Appeal, by this court in Bussey, when my Lord the Vice President articulated the nature of the inquiry into foreseeability. And I preface this by saying, of course, that was a post-65 case in the context of mesothelioma knowledge. But we say the logic follows through. And one of the important passages, which was cited by the judge at paragraph 40, has direct application here. Perhaps I could take the court, if I may, to paragraph 63 of the judgment in Bussey. It's at tab 28, pages 1061 to 1062.
Sorry, I have got it marked. I've lost it. Oh, find it. Yep. Which paragraphs do you say?
My Lord, I would invite the court perhaps to read the whole of paragraph 63, if the court would indulge me in doing so, down to the C, ending with fatal illness is significant.
Yes.
Lord, and then if I could take the court to opposite D, under this, beginning with a little b. If the answer to the first question is that Anglia should have been aware that Mr. Bussey's exposure gave rise to such a risk, including that there was no safe limit. My Lord, I'm conscious of my audience.
Don't worry. I mean,
I'm not going to tell
once it's out in the open, I have no more authority to say what it means than anyone else.
And I'm also conscious that this was post-65 with mesothelioma in mind. But I say that this logic applies equally to the situation in which this employer found itself in 1949, because there was no safe limit. And I emphasize, of course, the words in parenthesis at 63B, the risk.
Yes, but the context was the only point on which I, and as it turned out, Justice Moylan were not happy with, or Justice Jackson's reasoning, was that he borrowed, I think, from Williams the phrase "an unacceptable risk of asbestos-related injury." We didn't like the idea that there might be no duty in circumstances where there was a foreseeable risk of asbestos-related injury, but it was all right because it was an acceptable risk. And that's what all this is directed to.
I won't argue with the court.
Well, I mean, no, I'm not saying anything from my own. You can read that. That's how the whole paragraph starts at 63. So what we said has to be read in that context.
Well, my lord, of course I accept that, but I say this. I say this. The same reading can be given. That is my submission, my lord. If the court keeps that formulation in mind, that not knowing the word, that essentially that an unknown can give rise to such a risk, and that includes no known safe limit. If the court keeps that in mind and then considers the judge's formulation in this case, at paragraph 41, page 112, he said, I consider that the Jeremson approach, as further clarified by Lord Justice Underhill and Bussey, is the approach I intend to adopt. I do so mindful of the fact that in the present case, and similarly to the assessment in Bussey, there is no reason to suppose that the hospital took any steps to measure the level of exposure which the deceased was exposed to, and could not have known and did not know whether it was above or below any maximum safe limit. And so I say, on the judge's own reasoning, he ought to have applied this court's ruling in this court's approach, I should say, in Bussey.
He obviously goes on in paragraph 43 to separate out the Bussey questions.
He does. And my lord, yes, and his separation was essentially said that significant is meant to exclude risks which are purely fanciful. Any real risk, albeit statistically small, of a fatal illness is significant. And my lord, that's the crux of this appeal. If a court accepts that our submission that this did give rise to a risk on the literature, my lords, and I say the judge was in error. And if the court doesn't, then it clearly is a difficulty for me. I mean, ultimately, the defendant knew that Mr. White was being exposed to what had been described as a highly dangerous material. He said there was no real reassurance. I pray in aid what my learned friend has taken the court to the literature from, for example, from Conway Plum, the former superintendent.
Can you speak up a little?
Sorry, I beg your pardon. I also rely upon the documents that my learned friend took you to yesterday. For example, the textbook from Conway Plum, who was the former superintending inspector of factories. But we say that the most that could be said is that the employee knew it was unsafe, or asbestos was unsafe, and that more research was needed.
The thing is, plainly, employers knew that asbestos in certain quantities was unsafe. The question is whether you can go on from that to say that they ought to have foreseen that any quantity was unsafe.
Well, my lord, yes, I say that is the next logical step from given the state of knowledge as it was at that time. But my lord, that's the crux of the appeal, essentially. My lord, the third point, I am conscious of the time. I've dwelt on these at length. I'm sorry, is a short one, which is that the judge put excessive weight on the level of exposure being below the what's called the ACGIH TLV. My lord, perhaps I would simply refer your lordships to the skeleton argument on that point, rather than deal with that point in any detail. It's a relatively brief point. I'll give your lordships the
Would you quibble on the authority, or would you panel or disagree on the authorities? An employer would be entitled to look at the documents we've been taken to and take assurance or take comfort from them. I don't think it's submitted by either respondent that they are themselves determinative and that anybody who comes in below the levels is non-negligent. If they were submitting that, that's contrary to authority. But you're not submitting that they're not relevant, are you?
well, my lord, they form the background. They are documents, and this is obviously in this case the defendant is the state. My lord, I say they had very little relevance because no steps had been taken in the White case to assess the level of exposure. So simply it's something they didn't know. They hadn't measured this exposure. They had taken no steps to identify or assess it. I simply say it's irrelevant to the facts of this appeal. My lord, it is possibly worth. I mean, obviously, the facts of this case are exposure before 1960, and what the judge was referred to as the American Conference at levels. It is possibly worth looking at some of the limitations to that document, if I may do so briefly. My lord, it's a short point. If we could just perhaps go to it, I think it does. On its face, it recognises its own restrictions. It's in the.
Okay, just remind me first though what the judge, what degree of reliance the judge placed on it.
Essentially, my lord.
Let me just read
Just
them.
Stuart-Smith's.
I see. Okay.
Essentially, it was a potentially yardstick for what was safe measured by standards of the day. Well, the document itself, to which reference was made, appears in the white literature bundle at 206. It begins at page 201, but the relevant part is 206. It's a reproduction of the 1965 dust and fumes in factory atmosphere.
Sorry, which one are you in?
I beg your pardon. It's the white literature bundle, the white core bundle.
The white core literature.
Sorry, no, the white literature bundle, not the reference library. My lord, on the left-hand column on page 206, you have the point made by my own friend Mr. Rawlinson that the sentence attempts should however always be made to, in the first place, to use a substitute. But then specifically to this document, moving down that page, it says we reproduce in this booklet by permission a list adopted by the American Conference of Governmental Industrial Hygienists at their meeting in April 1964 of threshold limit values for a number of substances which may be injurious or offensive if absorbed in the form of dust or fume. The condition of reproduction of this list is that it should be published in its entirety and without amendment, and careful attention should be given to the preface which explains the thinking behind it. It must be remembered that it's based on experience, practice and research in the United States because of the difference in climatic, genetic and industrial conditions in this country, and because certain materials may be obtained from different sources of supply. British experience is not always the same, and therefore in a few cases, particularly where mineral dusts are concerned, British experts may suggest rather lower values as more appropriate. My lord, I don't make too much of that, but that's a necessary qualification of the value of this document and these threshold limits. My lord, in answer to my lord Justice Stuart-Smith's points, Dr. Hewson himself, in fact, recognised that the TLVs wouldn't be a safe indicator of any threshold. It's fair to point that out. That's at supplementary bundle, page 47 in the White Appeal 6.4.3.
The supplementary bundle, which
I'm sorry, the white supplementary bundle, page 47, paragraph 6.4.3.
yeah, thank you.
My lord, I'm coming to a new point. I don't know if that would be.
How much longer do you think you're going to be?
My lord, if permitted, no more than half an hour.
Speaking for myself, and my lords will speak for themselves, the point I made earlier about how your 6 points really just tend to recycle. So I think you need to just look at them carefully and see to what extent they add value.
Right, well, my lord.
Not saying they don't, but I think you need to just focus on that. And if it's, you just find yourself saying the same thing again,
Very well.
don't. You say you wanted to deal with certain points raised in the respondent's notice if you had time. Well, I think this is the only time you're going to get, because the timetable didn't build in a right of reply. So I think, again, we haven't really focused on those points, and it may be that they're not central, but I think if you're going to take half an hour, and if they require a bit of time, you need to deal with them then. Mr. Platt, my feeling, I'm bound to say, is that if Mr. Steinberg does indeed only take half an hour, you're not going to be placed in any real difficulty.
Lord, I hope not. I do want to go through some of the documents because I do think it's important.
Yes, no, not just it, but you will, on any view, have, well, perhaps not quite an hour and a half, but you'll have a bit, I think you'll have enough time to take us the documents we need to be taken to.
Did the timetable have quarter an hour each for replies?
Originally, we put that in, we did.
It did.
Yeah.
Well, that's why I thought
4 till 4:30.
you know, that would mean that if they're going to really take those up, you're going to have to be sitting down by 4, which means that if Mr. Steinberg goes on to 2:30, you've got an hour and a half. But given the position of the respondents in these appeals and so much ground's been covered, I would hope you'll be able to deal with this in that time. Mr. Steinberg, but that is, I think that has to be an absolute,
I'll take the message.
2:30, and you will get plaudits from the court if it turns out to be 2:15 or 2:20. But I find that those plaudits don't count for as much as they should.
They do in my case.
Okay, right.